Welcome to the Supported Living Property Podcast with your host, me, Lisa Brown, the place to learn about supported living property investing. Hi Alice, it's great to have you here today. For people who don't know you, do you want to introduce yourself?
Yes, more than happy to. So I'm Alice. I live in Plymouth and I've worked in housing since I was the ripe old age of about 18. And I have worked in all sorts of different types of housing, supported accommodation. I've worked for some bigger registered providers, some slightly smaller ones. And most recently, I joined a wonderful place of work called Havencare, who are predominantly a care provider, but have accommodation and are looking to grow their accommodation offer. And then they took me as a part of that.
Brilliant. Thank you, Alice. So we were going to talk today. This came out of a conversation we were having around challenges that you guys were facing anyway, wasn't it?
Yes.
So do you want to explain a little bit about what we're going to talk about today?
Yes. So we had a really interesting conversation about court of protection and deprivation of liberty. It's not something that I've experienced much or even at all really in previous roles. And then moving over to Havencare and kind of really picking up more of the kind of CQC and care information, I sort of went, well, who signed our tenancies? You know, how do our tenants sign tenancies? And that is where I've entered this interesting world of court of protection, the many different types of court protection sort of uses, and deprivation of liberty safeguards and the function of them.
Amazing. So we're talking about tenants here who probably have a learning disability, have autism, or maybe have some very complex mental health. That's who we're talking about as a tenant group really for
Absolutely.
this?
Yeah. So we predominantly support people with learning disability and autism. We do support some people who have kind of brain injury or acquired brain injury, but that is the predominant sort of client group that we're working with.
And so we're talking about people who are deemed to not have capacity, and that's why they would need to have a court of protection. Is that right?
Yes. And the world of capacity is a huge, wild and wonderful world because there are different types of capacity. Our capacity can fluctuate. And some individuals may have capacity to make decisions for themselves. But when it comes to some of the more significant decisions, so cause and effect consequence, if we think about housing law and understanding a tenancy in consequence of not paying, for some of our tenants, they may be able to sort of pick whether they have a pink room or a purple room and have preferences, but they might not be able to sort of understand paying their rent, the expectations of a tenancy, and those individuals would generally have an appointee or a deputy. Um, and that's where we enter into the world of a court of protection to sign a tenancy.
So who would be an appointee if we have somebody who has a learning disability, say? Who would that appointee typically be?
So we do have a service in Plymouth who are purely appointeeships. An appointee could be a family member, it could be a friend, it could even be a partner. To be recognised kind of appointeeships, it's usually done through the Court of Protection or sort of delegated through court, if that makes sense. But there are quite big differences between appointeeships and deputyships, which again I've learned. An appointeeship is purely for kind of financial decision making, so really kind of low level. Can I afford this? Am I making sure that I've got the right benefits for this person? A deputyship for finance and property has a slightly more significant role, in the fact that one, they're able to sign a tenancy for somebody, but essentially the role of an appointeeship or a deputyship is to ensure that the person is having decisions made that is the best for them, that they aren't being exploited, and that the place that they are living or the decisions that are being made about their finances are absolutely the right decision for them.
And so you're looking at this from a situation of making sure that people have valid tenancies is the first point to this, isn't it? Because,
Yes.
as property investors, we're used to people signing tenancies. There's lots of people, in the supported housing space are very used to tenancies, but it becomes a bit more complicated when someone maybe doesn't have capacity, doesn't it?
It absolutely does, which is what I've experienced. And actually, there are a number of providers that sort of deal with that in a really different way. Um, Essentially, at the point of somebody applying for accommodation, one of the things that we ask for the referrer, whether that's the social worker, family member, or maybe a support worker, is whether that person has any court of protection in place. So that could be they might have had a court of protection for a one-off decision, but that wouldn't necessarily cover them signing a tenancy. They might have had an emergency application done for a court of protection, and again, that might not necessarily cover. But I would say what I've experienced the most is family members are generally granted kind of a court of protection for health and well-being. So they're able to kind of input on health decisions, kind of operations, medical interventions, but that doesn't cover them for finance and property. And I guess within that, what I've also found is that people will often have an appointee for those financial decisions, but those appointees are not able to make decisions on where they live, and they're not able to sign a tenancy, which I think is a common misconception that appointees can, as well as thinking that family members can sign tenancies and make decisions.
So it's complicated, isn't it? And I think I can imagine a lot of their care providers and support providers listening to this going, oh, not sure actually if some of our tenancies are valid here.
Yes, and this is where I think different providers have different approaches. So you can have a license, which can kind of cover in a temporary measure, but essentially, when somebody has an unsigned tenancy, there are some queries in it, and it doesn't necessarily make it kind of an illegal tenancy, but what it does is it doesn't offer that legal protective framework for the landlord or for the tenant. And when you consider our tenants, are individuals who are people who need to have somebody to make sure that you know they're being treated well and they're looked after. That's then adding another layer of actually it's really important that that tenancy is legal, and it's kind of holding those sort of frameworks around rents and repayments, but also the other way, that making sure that the landlord are accountable for the service they provide, or you know, for the tenancy that they offer, making sure that that's really solid in an agreement. So I have found lots of different ways that people deal with it. Some providers will ask for that court of protection to be applied for before they will even consider housing somebody. But Lisa, what I have found is that once you've made a court of protection application for a tenancy, the typical wait is around 18 to 24 months.
Wow.
Yeah, that's exactly what I said. And I'm like, well, can't we just get it done? And so quite often, I think that's where providers are taking the approach of going, okay, so as long as we have evidence that this is applied for, we're going to set up a license, or we're going to have a tenancy that might not be signed, but what we're going to do is make sure that the social workers, family members, support providers are all aware of what we should be providing, what we expect in return, and we are comfortable that that court of protection has been applied for, and we will both wait out that process. But
Because
it
you
is a
can't
really
have
interesting thing.
yeah, you can't have someone waiting 2 years to be housed purely on a court of protection wait. That's crazy, isn't it?
Absolutely.
Yeah.
And that's the thing that I think I was the most surprised about when you consider social housing, and you know, I think everywhere does it differently, but we have what's called like a Devon Home Choice in our neck of the woods. And social housing providers working at LHA rates are not going to hold off and avoid property for 2 years.
No.
But also, because they're not supported living providers, they're not as comfortable with having that period of time waiting for that court of protection. And I've found it quite shocking, to be honest, that this is a process. And it makes a lot of sense. Obviously, within housing previously, we worked with people who had capacity, who could sign decision making sort of paperwork, or maybe even an easy read version of a tenancy.
Mm.
But actually, the thought of somebody desperately needing accommodation, and there are so many scenarios, parents passing away, carers no longer being able to support somebody, loss of funding, whatever it might be,
Mm.
where that person is then in this position of not having a secure tenancy or a place to go as quickly. And even then, it's pretty difficult to get housing full stop at the moment, but
Yeah.
even more so. And it feels like a hindrance that really shouldn't be there.
No, no, that's really frustrating. So the court of protection would appoint these individuals on that the deputy or the appointee on behalf of the individual who doesn't have capacity. That's the role that they play. They're not going to be the people. It's not the court of protection signing the tenancy. It's that they're appointing
No,
the person to do that. Yeah.
no, and I had to tap into some of my support colleagues for a little bit more of an in-depth understanding of the process. Because essentially you can utilise something like a best interest decision between a social worker, a care provider, maybe even a GP to go, this person is much better and will have a much better life living in a house than they would in a hospital, for
Mm.
example. At the point of that best interest decision making, what would then happen is an assessment of capacity. So the individual would go through a process with generally a social worker, but it can be a GP or even a mental health advocate to go, has this person got capacity for finance, for property, for choice making, fine, whatever those things are. And if it's identified that they would not be able to confidently sign and be held legally responsible for a tenancy, that is when the court of protection application should be made. Who that person is appointed will depend on that person's situation. So there are some parents who are granted that. They will, they might have already had the health and well-being and they've gone through the process and they're appointed as the best person to make a decision. It could also be a social worker. It could be that they're appointed through a deputyship. So we have some deputyship services in Plymouth, and they might become appointed to take over and kind of make sure that those decisions are made in the best interest and generally continue working with them.
Fantastic. Does that then need renewing? Like if you've been, does the Court of Protection then need to meet again in 5 years to say this is still the right person to support
Yeah.
the
So again,
appointee?
my support colleagues gave me a little bit more on this.
Yeah.
Um, any kind of deprivation of liberty safeguard decision or court of protection decision is for that decision at that time. So somebody might have a deprivation of liberty within their home, for example, where it is assessed and decided that the sort of best course of action is that they're not able to run out of that front door independently. And so a lock internally is put under that kind of deprivation of liberty for safeguarding reasons. However, that person may have a change in their support. There are some fantastic ways of supporting people that might reduce risk. And so if it's assessed there's a need for change, then absolutely it would be reviewed. Similarly with accommodation, if somebody has, say, left hospital and gone into maybe a small one-bedroom flat and that was signed through the Court of Protection, if it is then decided that, and that was done as just a one-off decision, signing of the tenancy, but wasn't necessarily a deputyship, if that person was then to be assessed or a best interest meeting was assessed, or the individual decided they didn't want to live there anymore, then absolutely you would have to go through that process again. And that's the bit that I find surprising.
When there's such a long wait, that's really frustrating, isn't it?
Absolutely.
Yeah, yeah. Now you talked a little bit about deprivation of liberty there. Now what's that about? Because sometimes that's referred to as a dole, isn't it, when you hear people
Adults.
talk about it?
Yes,
So
and I remember they were going to change the terminology of it for a while, and then that got incredibly confusing when they decided to keep it. So essentially, a deprivation of liberty safeguard is put into place under the Mental Capacity Act 2005, I believe. If I've got that wrong, my support colleagues can judge me heavily. And it's essentially put into place so that decisions made around that person's care, their living arrangements, are best for them. And it's essentially to prevent unlawful deprivation of liberties taking place. So to prevent somebody, for example, having the front door locked if they don't need to. It's making sure that actually at any point decisions that are made are done for that person's best interest and safety.
there was an example. There's a property that I did where a young man needed there was a dole in place to protect the young man who would overeat, and so we needed to be able to lock the kitchen at certain times of the day so that he couldn't just free range because he would take food and eat raw food and stuff that wouldn't be safe for him. So that was in place. But if that hadn't been in place, it could be seen as being, well, actually, they're depriving him of
Absolutely.
food that he should be able to freely range and go and get snacks if he fancied a snack. So there's a
Yeah,
fine line, isn't there? Someone needs to make that decision about where that's kind of like
absolutely. And it's
controlling
important.
behavior and where that's
Yeah.
yeah.
And even more so why it's important that those deprivation of liberties are regularly reviewed and assessed, because as we've said, actually that individual might have or present with behaviours or challenges because of something going on, but actually that might change in the future. So again, it's always making sure that the decisions around that person are always within their best interest for their safety, and it allows care providers and support workers to be able to work with somebody in a way that may feel a little restrictive, but be confident that those restrictions are absolutely for that person's best interest. Your example is a fantastic one. I think people sort of going out into the public and the community might be another example, if somebody would be at risk to themselves or to others if they were to go in the community on their own. Because it's quite restrictive if you think about somebody not being able to go outside on their own.
Yeah.
But actually, if that would present a huge risk, then absolutely it makes sense that that's in place to protect that person, actually.
Yeah, yeah. So it's a really fine line, isn't it, between providing the right support and being abusive or controlling. And that's why there needs to be oversight on that decision making. It's
And
not.
I think that's it, Lisa. I think it's a wonderful thing. But I think what I have learned is that something that should be in place for really positive reasons, actually within housing, appears to be quite restrictive in terms of accessing accommodation. The sort of providers or social housing providers or private landlords that would be willing to work with somebody who maybe doesn't have the capacity and doesn't have that tenancy signed, that there aren't many providers that are going to be comfortable in that situation, especially if they don't have that understanding around what it means and they don't have that legislative kind of back knowledge. It's
Yeah.
quite intimidating, actually, I think, to consider accommodating somebody in that way.
And I think it's just another sort of level to supported living that lots of people don't consider when people like, particularly property investors. Yeah, I'll just jump in, I'll lease my property to this lovely provider. That's all I'm going to think about, and I'm going to swan off into the sunset.
Absolutely.
A lot of property investors we know don't do sufficient due diligence on the providers they're working with. And this could be part of your due diligence process, couldn't it? About how do you check that this is a valid tenancy? And, actually, how do we know that this is a tenancy that should be in place that.
Absolutely. And often when we talk about supported living, you might think of people approaching as homeless going into supported living, people in recovery, and, individuals with capacity having the ability to sign that tenancy. You often wouldn't even consider, how is this tenancy going to be signed? Am I confident that this provider can? But I absolutely entering into the world of that much more complex care where we really are, housing somebody that possibly needs 24/7 support, maybe has 2-to-1 or 3-to-1 staffing. It is absolutely a really good thing to make sure that your provider is working within, and especially even for RPs and housing individuals to actually, because I know I've certainly had this experience going, okay, so we really need to consider this as part of our referral process, consider it with voids and allocations, and really having a clear policy on that and making sure that that's written in.
Yeah, really, really helpful. Thank you so much, Alice. Thank you for explaining that. It's quite a complicated
It is.
area.
I hope I've done it justice.
I think you have. I think it's been a really good sort of introductory for people to understand it. So thank you ever so much. All right, take care. Thank you.
Thank you.
Bye. Thank you for listening to this episode. If you're finding this content useful, then maybe it's time you join the Supported Living Property Network. If you're not already a member, then let me explain what's included. The network is a unique community of property investors and providers coming together to create quality supported living homes. If you're a property investor, you can list property on our portal for our provider members to see. You can access the demand portal where our providers list where they need property, so you can buy property to order. If you're a provider, you can access the property portal to see where our members have property available for you to lease, and you can list where you need property. We do not charge any additional introduction or sourcing fees. You also get access to our monthly training sessions with industry experts to help you understand supported living property and keep up to date. You get access to our monthly online networking sessions to help you connect with property investors and providers. I've written 2 training courses, one for providers and one for property investors, to help you get started in supported living property. We have a membership area filled with resources that you need, where you can watch the previous training sessions too. You get all of this for only £47.50 plus VAT a month. And because we do not want you to stay unless you think it's incredible value, you can leave at any time. Just give us 14 days notice. Simply go to www.supportedlivingproperty.uk. That's www.supportedlivingproperty.uk to join us now.